So we're going to talk about bylaws today. It's an exciting subject, as you all know. But it's actually really relevant, and it's important that all of your strata corporations really start to review your bylaws. The main reason for that is that the CRT is coming. So the CRT is the Civil Resolution Tribunal. It's an online portal that's going to be launching early next year, and it's going to dramatically remove the barriers for the homeowners to challenge the strata corporation. So what does that mean? That means if you've levied a fine, what it's going to be able to do is they're going to be able to challenge that through an online portal that has all the judicial power of a court, and you really need to make sure your house is in order, specifically what we're going to talk about, your bylaws and the process you apply them, so that when you actually levy a fine or when you send a warning letter, it's going to be able to be a stick and if it went to the CRT. So it's really a relevant topic. As you all know, changing bylaws takes some time, so this is the time to really start reviewing and going through it, and we're going to have some really take-home tips that are going to be important for you to recall. Max didn't mention this, but we'll also be sending out the details, so you don't have to take notes furiously, but by all means, if you want to take them, go ahead for it. So with that, now is the time to review your bylaws. CRT is coming. We're all scared, and we want to talk about the proper procedure to do that. So I'm going to turn it over to Jamie, and he's going to talk about the creation of bylaws.
Okay, great. Thanks very much, Sean. Maybe we can flip a slide or two forward.
Oh yeah, it's my job. There we go.
Perfect, perfect. As Sean mentioned, bylaws is just a very titillating subject, isn't it?
Yeah.
Yeah. It just keeps us awake, all hours of the night, and I have to say it actually keeps me very busy. I've probably done about 70, sets of new bylaws in the last couple of months. So I think there's a number of folks out in the crowd who have, tapped me or my firm to do that, and I think with good reason, as Sean said, the CRT is coming. I'm actually going to be an adjudicator with the CRT, so I'm not quite sure how that's going to work when I'm faced with some bylaws that I helped to draft, but anyhow. So let's start out by saying, why have bylaws? You all know that strata corporations are creatures of statute. So the statute applies, it governs, and Section 119, Sub 1, makes it, it's mandatory, it's a must that strata corporations have bylaws. Okay? I liken strata corporation bylaws to municipal bylaws because they do the same thing. They regulate, they control, they kind of govern the behavior within your community or in the bigger community in a municipality. Bylaws are basically there to kind of help you understand what it is that you're living in, and from the council's perspective, how to move forward to regulate use and control use and activities and so on and so forth. Specifically, you'll see that Section 1192 of the Act, and I'm not going to go into detail about what each of these sections of the Act says because Sean said this will be available later and the sections are there for you to see. But Section 119.2 basically provides the overview of what bylaws provide for, and they're for the control, management, administration. You control what happens in a strata lot, what happens on common property. Okay, in the absence of filed bylaws, the standard bylaws apply, and most of you probably have relied on standard bylaws, when there's been gaps in your bylaws. What you need to realize is that this is an opportunity for strata councils and owners alike to get together to try and figure out what bylaws they want to implement for the regulatory component of the strata corporation. Just a little bit on rules. You can also have rules. Section 125 of the Act deals with rules. I can say that I probably drafted about 5 rules in the last couple of years because strata corporations simply like to have everything neat and tidy in a set of bylaws. You can have rules if they conflict with the bylaws, they're not going to apply. There's a mechanism for passing them and adopting them, so if you choose to have rules, sometimes amenities facilities are in need of rules, there's a process available for that. When it comes to making or changing bylaws. You can be as creative as you want. I've often had people say to me, how do you solve this problem? And first of all, lawyer's answer is depends. Second of all, my answer often is, well, do you have a bylaw that deals with it? Because if you don't have a bylaw that deals with it, I think you can be creative in many instances and try and put together a bylaw that's not offside the Strata Property Act. So for example, and I just rhyme a few off here, you can have bylaws that relate to the sale of a strata lot. That's set out in section 122. You can have pet and age bylaws. So we're going to talk about that a little bit later. You can adopt a voluntary dispute resolution bylaw, although I think that it's not worth the paper it's written on, unfortunately, because it doesn't seem to do the job. You can limit or prohibit rentals, which is provided for in section 141 of the Strata Property Act.
So I think to build off what Jamie's saying is bylaws really need to be a living document. They're not a static set of bylaws that you bought the building, it had those bylaws, and they never change. Really, the bylaws need to be looked at as ever evolving. Why that is because strata living is changing, right? Remember smoking, and there used to be that ashtray in the plane in your armrest? They don't make those anymore, right? So everything's changing, so we're seeing more and more stratas clamping down or reducing the ability to smoke in a strata lot or around a strata lot. Short-term rentals, Airbnb, that's only been around 7 years, and look at the huge impact it's made on everybody here. Pets, we're seeing more and more leniency to more and more pets in buildings. A decade ago, it would be rare to have a dog in a strata lot. And then legislative changes. Soon to be, you'll be able to terminate a strata with an 80% owner approval. And so those buildings that have deferred maintenance, a developer will be able to buy all the units in the land and they'll be able to terminate that strata. So as things change, we need to realize that the bylaws need to change, and we really need to get a good understanding of how the bylaws apply and if they're up to date with what the ownership wants and needs. A tip is to review your bylaws not just before your AGM. That's typically what happens. And then your knee-jerk reaction like, oh wow, we need a move-in bylaw, right? And then we're going to put something together quickly, and then we get asked a question at the AGM, and we don't have a really good answer. So really a good rule of thumb is on your 6th fiscal month, so 6 months into the year, put it on the agenda, look at your bylaws and really give them a good review. Is there things you need to change? How can they be improved? What's changed in your building? And sometimes they don't need to change, but sometimes it's a good time to take that opportunity to fine-tune it and propose that to the ownership. So how do we create those new bylaws?
Well, let me just follow up on something that Sean has said. I think if you're starting your review 6 months before your AGM, you might actually need a bit more time, depending on how often you meet as a council. I've had some bylaw reviews that have taken about 16 months because, council gets engrossed in other things such as remediation, depreciation reports. We've all had fun with, those, haven't we? So it really is important when you roll up your sleeves to make sure you give yourself enough time. Don't try and rush the bylaw amendments through without giving them the time that it really requires, because generally it comes back to bite you in the backside if you try and do that. With respect to the bylaw amendment, bylaw change process, I talked about the standard bylaws being the bylaws that apply. So you can amend those, you can add to them, you can take them away, you can do whatever you want within the kind of the auspice of the Strata Property Act by simply putting the package together and taking it to a general meeting and passing the proposed changes by 3/4 vote. Once upon a time, you didn't have to file your amendments in the Land Title Office for the bylaws to be enforceable. Now you do, so that's something that you want to make sure that once you have actually gone through that process, pass them at your general meeting, AGM or SGM, that they're registered in the Land Title Office. Just kind of a bit of a segue here, a lot of my clients prefer to have a general meeting just for the passage of bylaws rather than piggyback it on a very lengthy AGM agenda. I think that's a great idea for the most part, unless there's a real timing issue in getting the bylaws passed, let's say, at a general meeting. So just something to keep in mind. It's also important to keep in mind that bylaws do not have retroactive effect. I've seen a few written that suggest that they do, but case law, in my view anyhow, confirms that they don't have retroactive effect. So if you're trying to stop something from happening in the future, it may be that you can't enforce it against a particular owner. I'm thinking of a case going back to '96 where a hot tub was involved and they tried to close the barn door after the horse had got out. We're going to talk about smoking in a little while, and I have a bit of a different opinion as far as smoking bylaws. Once you've got your bylaws, what do? Well, you want to enforce them, but you don't want to be the condo cops or the people who have to march around the property, day in and day out, hour after hour, kind of, checking parking and so on and so forth. But you want to be able to have bylaws that you can enforce and are enforceable. You see down on the slide, Section 121 of the Act deals with bylaws that are not enforceable. So it doesn't do you a whole lot of good to be creative but not make sure that your bylaws at the end of the day are enforceable. And so that's where you require, I think, input from your manager, and it's good to have a lawyer look at them to make sure that you are on the right track as far as enforceability is concerned. I wouldn't want you to put all the time and effort into bylaws just to find out that, that they're not enforceable. And Section 121 really is kind of the penultimate section in the Act that deals with unenforceable bylaws, whether it's a human rights code or whether it's something such as a bylaw that has an impact on your ability to sell your strata lot. There are exceptions, though, and that's referenced in 121 as well. You can talk about bylaws that prohibit or limit rentals, bylaws regulating the sale of a strata lot. That generally has to do with signage, open houses, showings, things of that nature, and bylaws restricting the ages of persons who can reside in a strata lot. I don't run into too many age restriction bylaws these days, but from time to time they do cross my desk, and they may, pop up as an issue for you as well. I've already said it's important to make sure when you're going through the motions that the bylaw package that you're going to put in front of the ownership is, to the best of your knowledge, going to be a package of enforceable bylaws. So, enforcement. Ongoing. To enforce a bylaw or a rule, a strata corporation may do one or more of the following, and Section 129 sets out what you can do. Most strata corporations generally go with option A, which is to impose a fine. Some strata corporations will remedy a contravention of a bylaw under Section 133, and that can open up a whole can of worms. For example, and I've had this happen in a couple of instances, an owner has secretly renovated his or her strata lot and has reconfigured piping and wiring and so on and so forth. There's code violations up to yin-yang. I've had a couple of clients who have actually had to go in and remedy a contravention under Section 133 and then charge those costs back. Then you can deny access to a recreation facility. That seems to be a fairly kind of simple way to enforce the bylaw, especially if somebody is very keen to use a recreational facility, for those of you who have those facilities. When it comes to enforcement, and I've highlighted it here, don't forget that this section of the Act 129 gives you the ability to issue a warning. And Sean's going to talk, I think, a little bit about that, is that you don't have to come out with guns blazing all the time when it comes to enforcement. Look at your options and determine whether or not a warning letter is going to be sufficient. I think if it's a one-off infraction, it may do the job. Because what you do is you issue the warning, the contravention stops, and you don't have to put a fine on an account that you then have to worry about trying to collect.
Okay, so I'm going to talk about the 3 keys to successful bylaw enforcement. And I want to emphasize, I've literally dealt with hundreds of stratas and strata councils. So this is my opinion, and what I'm talking about here is based off of not just a couple buildings, but it's really a wide variety of buildings, different shapes, sizes, different areas of Metro Vancouver. The friendly reminder, I know it sounds really nice, but the friendly reminder letters and correspondence are really important. And sometimes strata councils get just so used to having to deal with these people that keep on breaking the bylaws that they just send out the $200 fines all the time. Hearing, they don't respond, $200 fine. And the friendly reminder is really important because what you're doing is you're not getting that owner to dig in. You're trying to say, this is a problem, you're bugging somebody, you're doing something wrong, and we just want to point out that the bylaw says this, and we ask you very nicely not to do the action again. And it's very, very effective. Most people in your buildings are good people, and they want to follow the rules, and they want to live in a community where everybody gets along. Sometimes I might speed, right? Sometimes you might speed when you're driving. And so just that sometimes people go into the gray area or they break a bylaw. It doesn't mean they're bad people. So it's really important that we're sending out friendly reminders so that we can come to a resolution. I've got this great example. There's a building in North Van called Vantana. And there was this lady, and she complained every morning, 5:30 in the morning, my neighbor above me is making this horrendous noise. He keeps on doing it over and over, and it's driving me crazy. So the council there was very smart, and they sent a very friendly reminder letter saying, hey, you're bugging somebody. And instead of saying, you're going to get a fine and you're breaking a bylaw, it was a very friendly letter, and that owner called, and I had a great discussion with him, and he's like, my wife's asleep. I get up at 5, my wife's asleep, she doesn't wake up. There's no way I'm making this noise. Can I talk to the person that's complaining? Because I genuinely want to figure it out. So we asked the lady downstairs, yep, she's great. And so the two met, they even had a glass of wine, and they had a very good time of trying to figure out what the noise was. And what it ended up being was a coffee maker. So he would make coffee in the morning, and it was very quiet in his unit, but he would go down to her unit, and he'd listen, and he'd be like, this is really loud, right? So he moved the coffee maker, problem is solved. But if that strata council had decided to levy saying, we're going to levy a fine, and this is a really big infraction, he would have dug in, and then there wouldn't have been that time to resolve it and really form that community bond. So next time when you're coming up with a situation, the knee-jerk reaction is, this person's doing it intently, I'm going to fine them, but really we need to think about it, and we need to send a friendly reminder and let them know, hey, it's bothering. If someone's had a loud party at 4 a.m. and they've woken up 18 people in the building, that's a different situation. But we're building bylaws for the 80 to 90% of the time and 80 to 90% of the people in the building. And we want to foster that sense of community. So don't underestimate the power of the friendly reminder or correspondence. The second one is firm, consistent bylaw enforcement. If there's something that's important to the building, like waiting for the door to close before you leave, then enforcement of that bylaw needs to be consistent. And that's how you're going to shape people's behavior. That's how you're going to shape the residents' behavior, is if you continuously enforce that bylaw. Sporadic enforcement doesn't work. Sporadic enforcement, like we need people to wait for the door to close, all of a sudden we're going to issue like 20 fines and 20 warning letters, and then we're not going to do anything for a year. That doesn't really shape people's behavior, it just kind of bugs them. And so really what we want to do is firm, consistent. Pick the important bylaws that you want to enforce and really focus on them and consistently enforce them. And then third is, the council is the tone from the top. You're setting that culture in your building. So it's really important, council really needs to have this discussion. What do we want our building to be like? If you're in a high crime area, you want the tone from the top, the council to be, security is our utmost important. If you're out in the valley and it's a bunch of townhomes, maybe the most important thing is we want everybody to be a communal living and a happy place to live. But really the council needs to figure out, you are the tone from the top, what are we setting this building? And it's not like it's going to make an instant change, but it does take time and it's slowly going to evolve. I've got a really great story. I was talking to a strata manager today, and a building downtown, they bought a 15-foot Christmas tree, huge Christmas tree. I think it was $1,500. And they set up this Christmas tree, and then they posted a notice, we're going to decorate it this Saturday at 2 o'clock, right? And 40 people showed up. So it was a huge amount of people. And they had ladders, and someone brought some hot chocolate, right? And that's a feel-good story, but also all those people now have pride in the building. So when they're following someone into the elevator and that person drops some garbage, they're going to be like, hey, this is my building, and they're going to feel a sense of community. And that is the most powerful thing you can get. The most important thing with security is everybody knowing your neighbors, and the most important thing with bylaws is everybody feeling that sense of community. So I think it's really important when everybody goes back to their next round of council meeting to really have that conversation and inform on how we want the building to run. And then sometimes everything doesn't work out and you need some bylaws. And then we have to talk to Jamie again.
Nice segue. Just a couple of things before I get into the enforcement side of it. If you enforce your bylaws sporadically, pick and choose, maybe do some favors for somebody who used to be on council, it makes my job harder, and it's certainly going to make council's job harder to then go to the ownership and say, we need money to go to court to enforce a bylaw, because word is out that it's really a bit of a joke. Okay, so don't enforce them sporadically. There's lots of case law that says if you do that, if you sit on your rights, even if the bylaw is enforceable, the court is not going to enforce it in a particular situation. Sean brought up community, and when you enforce bylaws, you're enforcing your regulations against the people who live in your community. But from time to time, you have to do that. Two very, very harsh examples. Hopefully neither one of them are in the room tonight. Rose Jordison. Has anybody heard of Rose Jordison? How about Mr. B? Has anybody heard about Mr. B? No, he's not a movie star. He's actually was an owner. Two very, very extreme examples of the requirement of Strata Corporation to expend tens of thousands of dollars to enforce bylaws against individuals who didn't want to play by the community rules. Okay, so just keep it in mind. I know that there's nobody here that has those issues, but they do happen from time to time. So who can be fined when it comes to fining, and who's responsible for the fines? Section 130 gives the Strata Corporation the ability to impose fines on an owner if there's been a contravention by the owner, person visiting, or an occupant in the strata lot. The owner, in my view, is the primary target when it comes to fines. You can put the fine on the account. You can send the letter to hopefully an address you have for the owner, and you don't have to go chasing around the individuals who perhaps perpetrated the contravention if it's not the owner, but you've got the owner as the primary target. Sometimes you have to deal with landlords and tenants, and Section 131 of the Act deals with who can be fined and how you can go about fining for breaches by a tenant. Once in a while, tenants do have loud parties, or perhaps have animals that aren't complying with the bylaws, and you're looking at who you can impose the fines against. Section 131 talks again about how you can deal with fining tenants and fining landlords with respect to bylaw violations. The owner can pay these fines, and then the owner can go back to the individual in question. My preference and my advice generally is, again, focus on the owner, because you know where the owner is. The owner having a piece of the rock in terms of being a part of the community generally is someone who is more approachable than somebody who doesn't have really an interest in ownership or a pride in ownership. But you're going to run across tenants from time to time in buildings, and Section 131 deals with how you can go about chasing them. When it comes to fines, it's important to know what the Act says about the maximums and the frequency. Section 132 of the Act sets that out in pretty good detail in terms of the maximums and the frequency. Maximums now are $200 for breach of a bylaw and $50 for breach of rules. The regulations say that the governor and council can change those amounts from time to time. So those are the maximums, but you don't have to come out of the gate, as Sean said, with a $200 fine, up to $200. Section 23 of the bylaws, standard bylaws, talks about the maximum fines. So it's up to $200, up to $50. As far as frequency is concerned, you can see what 132 says about frequency and what Section 7.1 of the regulations says also in terms of frequency. Contraventions every 7 days, and it has to be for the same contravention. I had one file in particular, and this has to do with rentals, where for 30 months there was a rental contravention. Of course, it happened every 7 days, so the fines started to add up, as you can imagine. And I'm going to talk about, whether or not you can actually recover all of your fines. But that was what was kind of starting to add up in the owner's account, as it was getting into the tens of thousands of dollars because of the continued contravention.
So Jamie, out of that, if a Strata corporation is fining an owner and it's $200 per time, and they've got up to like $5,000, what are the courts saying as far as collecting those fines?
Good question. Well, for the most part, I think courts are relieving owners from having to pay all the fines that are on the account, assuming that your paperwork shows that the complaints are legitimate and the Strata has kind of followed the process from start to finish. Majority of cases that I've seen, they've been reduced by anywhere from 25% to as much as 75%. It's the rare case where it's the other way around, and it has to be as a result of a very egregious bylaw breach. The one case I was talking about, when it came to the rental, Strata had imposed $42,000 worth of fines. The court gave them $38,000 of that. In another case, I think the fines added up to about $22,000 for, I think, ongoing noise violations, and the court gave them, Strata Corporation, about 90% of those fines. But again, two very extreme examples, but ordinarily, you put them on the account, the judge is probably going to knock them down somewhat.
Okay. So I'm going to just talk about a typical scenario. We had a question, and some council members were interested in what happens in the back end. What's the whole procedure? So there's many, many variables, because it could be phone calls. Heck, we could get a fax as the management company. So I'm just going to run through a typical scenario, and then I'm going to add the CRT component to it at the end. So hear me out on this one. The resident leaves a phone message for the Strata manager regarding their neighbor smoking. Okay? Strata manager calls the resident back and asks them to make a note of the time, place, and duration of the alleged bylaw contravention. The resident then submits the information, and the Strata manager informs the Strata council and lets the resident know that this is going to be reviewed at a council meeting, or the council is going to review it separately. Strata council directs the Strata manager to send a friendly letter. So there's a letter that goes off saying, hey, you're smoking, you're bugging your neighbor, maybe you need to change your course of action. So that letter's sent out, and another complaint is received regarding the same unit with time, place, and duration. And this is a real life event that actually happened. The resident manager asked the neighboring units if there was anything noted, and the neighbor said, yeah, we had noticed it, and it bugs me. And then so they sent the Strata manager confirmation on place, duration, and time, and of course that corresponded with the other one that had been submitted. The Strata Council then directed the Strata manager to send a bylaw violation letter, which included adequate time for the resident to respond. So it's been alleged that you're smoking and it's affecting your neighbors. We'd like to hear your side of the story, and we're giving you 10 days to respond. The resident who allegedly broke a bylaw declined to respond or simply ignored the letter. The Strata Council authorized a $50 fine. In my view, very reasonable. The resident who had been fined calls the Strata managers and expressed their unhappiness at being fined. It was very long and loud expression. So the Strata manager in this case was empathetic, and explained the process and the decision that was made, and that's it. So it's fine. Now, in the future, the resident who is fined can apply to the CRT and to have the fine reversed. And the CRT is going to go through the process with that homeowner, and it's done online again, and it's going to be collaborative, so the Strata Council is going to have to provide some input as well. And they're going to find if the Strata Corporation followed the correct bylaw. So does this bylaw actually apply to what happened? Yes, it does. Great, continue the next step. No, it doesn't. Strata Corporation's going to lose. Was the process done correctly? Yes, the process was done correctly. That's fine. The fine's going to stand. Or maybe the process wasn't. Maybe a warning letter wasn't sent out, giving that owner adequate time to respond. Then chances are the Strata Corporation is going to lose. So you can see why tonight we're talking about bylaws. It's very important that going forward with the CRT that we make sure that the bylaws are applied correctly and that they're tight. It's really important that we make sure that the process is standardized and that it's following the act. And if we do that, we're not going to have any trouble. And the CRT is going to be pretty much open and shut. But if we don't do that, then that's when we're going to run into some troubles. So let's discuss a little more of the details, and I'll pass it back over to Jamie.
Sure. Okay. Before I get into the details, what John was talking about reminded me of a situation where an owner was levied fines on a monthly basis. She and her husband were retired and bought a strata lot that they thought was a good thing to let their son live in. Unfortunately, he wasn't a good community member or rule follower. And so they would, they'd be fined anywhere from, $400 to $600 a month because of his activities, including, drug deals and so on and so forth. They happily paid them, and at some point in time I picked up the phone and I talked to her and I said, "Why are you paying them?" She said, "Because I don't want them to move back home." So that was cheap punishment for her to keep her son out of her hair, so to speak. So if you get an owner who happily pays the fines, you probably have to kick it up a little bit, right?
Okay,
in terms of enforcement.
I want to jump in here though. Jamie's full of great stories, okay? But what we want to do is we're really designing the bylaws and the process for the majority of the people. And you're going to end up with some extreme cases, and Jamie's going to be there for you. But really, we want to design them because most of the time, again, those people want to be part of the community, and they don't want their drug dealing son in a home. It's a nice student that goes to SFU in my mind, in economics. There we go.
True enough, but I don't get the bylaw followers phoning me for legal advice.
That's right, that's right. It's not in your best interest, is it?
All right, so let's talk about enforcement. You'll see on the screen, Section 133 of the Act identifies different ways to deal with remedying a contravention. We've talked about fines and so on and so forth, but this section is an interesting section. I don't think it's used that often, at least I think the remedy itself isn't used that often. The corporation may do what is reasonably necessary to remedy a contravention, including doing work on or to a strata lot. The example I gave you about the renovations and the pipes, being altered and wiring and so on and so forth, might be a type of contravention where 133 could come in handy. Removing objects from common property, I've come across that a few times where people have kind of let their backyard become a junkyard, and strata corporations have cleaned it up because they have a duty to repair and maintain. And then, sub 2 talks about requiring the reasonable cost of remedying a contravention to be paid by the person. That's generally going to require a court application, because if you slap the costs on an owner's account, they're generally not going to voluntarily come forward and pay those costs. And I'm aware of at least one case where the court has indicated that, if the costs are reasonable, and the bylaw infraction can be justified, that in terms of the process to enforce, that those costs will be recovered. We talked a little bit about recreational facilities. I don't know how many of you have had issues with people perhaps breaching bylaws and you taking away rights to use a recreational facility, but this section of the Act 134 actually talks about corporations' ability to deny an owner, tenant, occupant, or visitor the use of a recreational facility for a reasonable period of time. So that's the test, is reasonable or reasonableness. The council gets to decide what is reasonable and whether or not, again, that punishment kind of fits the crime in terms of the the denial of the rights of use. But keep in mind that all these sections that I've talked about kind of lead up to the next section that I'm going to refer you to. And that's Section 135 of the Act. So You know, I asked the question, what if the warning letter doesn't work? Well, that's kind of step one. What if the, you know, the fines haven't worked, or not the fines haven't worked, pardon me, you know, the friendly neighbor chat hasn't worked, what happens? Well, 135 of the Act from a legal perspective is the kind of the penultimate section of the Act that has to be fully complied with before you can do either A, B, or C, okay? If you want to go to court to enforce a bylaw, you don't have to rely on Section 135 because you're not fining, you're not requiring a person to pay a cost of remedying contravention, you're not denying them access to a recreational facility. But because these three heads under A, B, or C generally deal with you know, the way that most strata corporations enforce bylaws, it's very, very important that 135 is fully complied with. And the section sets out in detail what you need to do. Sean talked about, you know, a typical kind of complaint process. So you need to get that into the queue. It has to be in writing. You need to give particulars of the complaint and an opportunity to the person being complained of to respond to that, including a hearing.
Next slide.
Next slide. 135 goes on to say that, you know, you've got to then, as soon as feasible, give notice in writing of a decision. So the council is the decision maker here, and they decide, after kind of looking at the evidence, whether or not there in fact has been a bylaw contravention. They issue a decision in writing so that you papered it, and from a lawyer's perspective, it's great that you paper it so that I can put it in an affidavit if we have to go to court. And then once you've complied, the council's complied with 135, you can merely go along and issue fines or other penalties for contravention, continuing contravention of that bylaw without further compliance with this section. So I've kind of identified the process in terms of the way I see it happen, from the perspective of you know, you making sure that, you know, you've done your due diligence and that no one is going to come back and say you haven't complied with Section 135. There is one case that I'm aware of where, because of the failure to comply with 135, the Strata Corporation's application in court was successful in terms of a finding that there had been a contravention, but they weren't entitled to their court costs, which were probably in the neighborhood of $7,000 or $8,000. So it kind of left a bit of a gap in their finances as a result of noncompliance. On to collecting fines. I often say to clients that fines are a windfall. We're one of the few provincial jurisdictions that is allowed to fine and collect fines for breach of strata or condo bylaws. Most other provinces don't have the similar type of legislation. And I think, frankly, you as council members would probably have an easier time of it if you didn't have to worry quite so much about the fine side of things. But it is what it is, so you do have to deal with it. And when the CRT, you know, finally happens, it's probably going to be front and center. Some fines, as I noted here, can be collected as non-lienable amounts, let's say for non-payment of strata fees. So you can go to court and get a judgment for the lienable amount that has priority over bank charges and so on. But it's pretty typical that I can also get judgment for the non-lienable fines for failure to pay the strata fees on a timely basis. And so you can recover those down the road, either through the owner or through the sale process if need be. You can use Supreme Court to enforce bylaws, compel compliance with bylaws, and as I said before, you can recover fines, significant fines, when you go through the Supreme Court process. It's not inexpensive to do, so you don't want to run off and take that step if you can absolutely avoid it, but it is there for your use. When it comes to bylaw complaints, something that I tend to have to repeat on an ongoing basis to my clients is that you've got to get the complaint in writing, and the complaint has to have some pretty cogent evidence in it that there actually has been a bylaw violation. You know, if you're walking down the hall and you hear a dog bark and there might be four dogs, in the units in the hallway, how do you know, whether or not that's the unit in question? It might be easier when it comes to a rental violation. It might be easier for a pet if you see the pet and you've got a 25 pounds and under bylaw and you've got a 100-pound Newfoundland dog walking up the hallway. But you've got the burden, you've got the obligation to make sure that your evidence is going to pass the test in front of a judge. Okay, strata councils have a duty to enforce bylaws. That's set out in the Act. It doesn't say in the Act you have a duty to investigate, but an offshoot of enforcement, I think, is to investigate first. Do your due diligence, make sure you've got the ammunition if you're going to take the next step to enforce it. Last thing in terms of enforcement, in terms of collecting fines, sometimes you can have the Form F withheld. Form Fs are required when a property is being sold. It can create some angst in vendors who have a lot of money on the line when it comes to fines, but I've seen it used quite successfully. Keep my fingers crossed, there have been no lawsuits as a result of botched deals when fines are being kind of talked about at the 11th hour after all the paperwork has been signed up. But it is a way to look at collecting fines if it comes to that.
Okay, so I'm going to talk about some key elements to stopping violations before they happen. So I think this is the more proactive approach. And we'll get back into some really wonderful things that Jamie's got coming up here. But I wanted to stopping bylaw violations before they happen. Really, you want to ensure your bylaws reasonably reflect what the ownership wants and needs. We had one strata, they had the standard bylaws, which just says one cat or dog, right? And so it turned out that just about a third of the building had 2 cats. So there's all these hidden cats all throughout the strata. And so the bylaws were totally out of touch. We're not going to make all these, in this case it was a bunch of elderly people, kick out their cats, right? The bylaws had to be changed to better reflect what the ownership's needs were. And I can tell you that bylaw passed. There was a great showing, everybody showed up, and that bylaw passed with no problem at all. So make sure that your bylaw is really reflecting what your community needs are. And don't budget for fines. You can budget for move-in, that's okay. But don't budget for fines. It's like saving money for your child's bail money, like start putting it aside. You're sending the wrong message. So don't budget for fines at all. Save for their education, maybe save for a social event, and that's coming up. Ensure the move-in procedure is top-notch. So I'm passionate about this, and I've spoken about this before. New resident, doesn't matter if it's tenant, owner, comes into the building, really they need to be engaged. If you have a resident manager, it's really easy. You just make it mandatory that they have to do a walkthrough with that resident manager. Resident manager has a checklist and they say, here's the garbage room, remember to flatten your cardboard, it goes here, don't leave any furniture. Here's the bike lock room, don't put the bike on your deck. Those little things, you can just hit those things that are really important and you can stop bylaw violations before they happen. Some buildings even have the owner that's moved in or the residents sign off that they understand and they've been shown these 6, 7 things that are really important. But then that way, there's no excuse coming later. And chances are people aren't going to read their bylaws. They should, yes, but they might not. So this is a way of really addressing those big ones. Wait for the gate to sign and then they're signing off on it. If you don't have a resident manager, find someone. It doesn't have to be a council member. It can be, that nosy neighbor that likes to be introduced to everybody that comes into the building. They can be tasked with that project. Or a council member, maybe they want to do it. But really engaging them, new people that move into the building, you'll be able to stop the bylaw violations even before they start. And then the last one is hold those community events. Don't budget for fines, budget for a social event. It really, again, binds that community and creates that self-enforcement of the bylaws that are much more powerful than the Strata Council sending letters with fines and stuff. So let's go to some weird and wonderful stuff that Jamie's got.
Okay, and again, before I kind of move on, I think it's the message that Sean is giving is a very important one, which is this is your community, and you as the Strata Council have enough work to do conducting the business, managing and administering, the Strata Corporation and so on and so forth, that this takes a lot of time, out of your other jobs, out of your other tasks to enforce bylaws. So if you can be proactive, as Sean has suggested, that's great. Because, you know, it does take time, and it costs money, you know, generally to enforce bylaws. So it's important to be able to get that point across to your new occupants, your new owners, your new tenants. Tenants sign that Form K, tenants' responsibilities, and so on and so forth. But get that message across, and come up with the creative ways to get the message across so that you have this, you know, this nice community that people, you know, kind of want to buy into rather than not. Now I get to talk about tenants, evicting tenants from strata lots. It's become a problem in many locations within the Lower Mainland because there's high tenancy rates, low owner-occupant you know, units, but high tenancy rates. And sometimes tenants run amok, and it's very hard to rein them in. Sometimes it's very hard actually to find the owners, who may be offshore, to do too much about it. There may be times actually when the owner, as a landlord, is too frightened to actually knock on the door and issue a termination notice. I've come across that in a number of instances. We do have a section in the Act which unfortunately is as I've said here, once upon a time like in a fairy tale, strata corporations could evict tenants for serious contravention of reasonable and significant bylaws. It really isn't available now because the residential tenancy branch has essentially said that strata corporations aren't identified as a landlord under the Residential Tenancy Act. Therefore, we don't really have the jurisdiction to enforce these termination notices that strata corporations have routinely given out. So the kind of the bad kind of conclusion to the story is that if you want to get rid of a tenant who is kind of creating a lot of problems in the building and breaching bylaws on a regular basis, you're likely going to have to retain legal counsel and probably make a court application under 173 of the Strata Property Act. Again, it's not easy because you tend to bump up against somebody who maybe has a high conflict personality, and they're going to push back. So hopefully I'm not talking to anybody here who has that type of situation, but it's not an easy task. It's not one that strata councils could easily deal with. And our courts right now have got a couple of these things on the books, and we're going to see actually whether or not they're going to kind of leapfrog over the two-step process that 173 of the Act talks about and simply issue eviction orders against tenants because they don't fit within the community. And again, that's coming back to that term community.
Can I jump in there, Jamie?
Sure.
So if an owner is scared of their tenant, there is specific companies, and they have the worst job on earth, that work with getting tenants out. So nothing illegal, but basically they'll work with encouraging that tenant and explaining the rules to them. And they must be made out of, they probably wear a bulletproof vest, but they actually will assist the owner if the owner is intimidated or scared in working with that tenant if they need to leave before it goes the distance, because we haven't seen too many being successful evicting tenants.
Yeah, another thing that owners can do if perhaps they're too timid or afraid is that they can actually contract with the Strata Corporation and appoint the Strata Corporation as their agent, because that is a category under which the Strata Corporation as agent can issue the eviction notice or the termination notice. So again, keep that in mind for situations where it might actually be applicable.
So Jamie, we're going a little long because you and I like to talk. More you than me. So what we'll do is we're going to go into a specific bylaws. And so if we can maybe just give Cole's notes on each bylaw and how the specific bylaw we wanted to talk about.
Sure.
That work?
Absolutely.
So you want to do smoking?
I'll do smoking. Anybody here have no smoking bylaws? Okay. You really don't need them because I think the nuisance bylaw does the job. And there's a case law to support smoking being a nuisance. But if you if you are wanting to take it to the next step and really cut back on smoking or prohibit it completely, I think there is a mechanism by way of a no smoking bylaw, and there's an example up here. You have to put it to your ownership and get a 3/4 vote, which may be difficult for the hardcore smokers.
That was good. That was Cole's notes. Pets? You want to do pets?
I can do pets as well, sure.
I'll do the next one, I promise.
Okay, okay. The standard bylaw, which I've identified here, talks about, controlling, securing pets and so on and so forth, and how many pets you can keep. I've seen pet bylaws that have bewildered me because of some of the things that they have tried to prohibit. I had one where it said that you must carry your dog or your pet across the common property, and I had one owner come to me and say, well, my dog weighs 75 pounds. How can I do that? There wasn't a lot of thought that went into the bylaws, but you can be creative. You can prohibit by size, type, or number. It just has to be reasonable. So if you've got issues with pets, and I love pets, and I think pets should be allowed in buildings, but a lot of owners and occupants don't necessarily feel the same way. So get a feel for the community, as Sean said, before you run out there and try and put something in place that isn't going to work.
Okay, I'm going to talk about noise then. So use of property, the standard bylaw for use of property addresses this. It says an owner, tenant, or occupant, or visitor must not use a straddle at the common property or common asset in a way that is a nuisance or causes unreasonable noise. The problem is that it comes up to the interpretation of unreasonable noise. So what I feel unreasonable noise and what someone else feels unreasonable noise is very different. So in the strata management, one of our common questions to someone when they call in regard about noise is, have you lived in a strata before? Because a lot of times it's, no, I just moved from a single family house. So a lot of times people move into strata and they're not used to living in close proximity to people. So they hear the neighbor having a shower and it really disturbs them. And then usually after a time they live in a strata, they become, it's kind of like moving from the country where at night it's dead quiet, right? I remember growing up, I lived out in the Okanagan. When there's a fire truck, we would get on our bikes and follow that fire truck because we were going to go see that fire truck. Now I live in the city. My kids, they don't even look at fire trucks going by, right? And so it really, it comes down to what the definition of unreasonable is. So the key to solving noise complaints is corroborating information. Get the caretaker or get a neighbor or have a council member maybe with a strata manager, go and assess the noise. And it's a difficult thing to do. We have to make sure that reasonable is what everybody would consider, or the vast majority of people would consider reasonable. I remember we had this one building, and this lady was passionate that her neighbor above was making this noise every 10 minutes, and it was keeping her up. Well, after a council meeting, a council member and I sat in her unit for a good 30 minutes. There was no noise. But for her, there must have been some small noise that really bothered her. And so she was really wanted the owner upstairs fined or evicted because they were a tenant. And really it came down to there wasn't an unreasonable amount of noise. So it's really important with noise complaints, how we address them is that you need to get more information. And usually that's talking to a neighbor, having a resident manager listen to it, having a council member go listen to it, and then everybody as a group can assess, or the council can assess, is it reasonable or isn't it reasonable? The other way of doing it is keeping a log of details, which include the time, the description, the duration of the noise, maybe a description of the noise. And then with that log, you can apply it as a nuisance. In fact, Jamie, do you want to talk about nuisance? I think that's the next slide.
I can certainly do that. Little segue when it comes to the log. A log is a wonderful idea because if someone is complaining, say, keep the log. I just got a petition on my desk earlier this week where it was a 3-year log of noise complaints, which wow. I think suggests to me that perhaps someone wasn't acting quickly enough to deal with the issues. But the log is a way for the council to be able to identify through investigation that there's some substance behind this. But keep in mind that when you kind of levy the complaint letter, the other person is going to ask for particulars. I think the log has to be disclosed. And more than one instance, I've had owners come back and say, look, I've got a plane ticket here that says I was out of the country, 30% of the time, or I was away on holidays, or what have you. So that just goes to say, this, I think, is the hardest bylaw to enforce, bar none. My 28 years, it is the hardest bylaw to enforce.
Yeah.
I think the second hardest one is the nuisance bylaw. Standard bylaw is set out in Bylaw 3.1a that talks about tenants, owners, occupants not using a strata lot, common property or common assets in a way that causes a nuisance or hazard to another person. Should be a period of it. So the strata corporation may wish, if it doesn't think that there's enough teeth in this type of bylaw, to look at adding something more to the bylaws. And when I see customized bylaw requests, generally strata corporations, councils are coming to me and saying, add more teeth to this nuisance bylaw. We can talk about nuisance as a problem when it comes to smoking. That's easily dealt with, but there's all sorts of other nuisances, and I just kind of give you a number of examples, whether it's noise or traffic, smell, vibration, glare, musical instruments, sound is a nuisance, allowing a strata lot to become unsanitary. This is a fun one. I had this as a file a couple of years ago, where a little old lady, I think this is what she did every afternoon about 3 o'clock. She got her garden hose out and she'd water it down and it would drip down to the unit below her. You know, that became a nuisance because it was just simply habitual for her. So the bylaw was in place and the bylaw was enforced, and finally she actually realized that she shouldn't be doing it. But again, this is creative, knowing what your community is all about. And I think just getting people to understand that when you live in close proximity, there's some things that you shouldn't be doing.
Okay. Next one I'm going to talk about is short-term rentals. This is a really hot topic, and we've even had whole educational events just on short-term rentals. So the standard of bylaws that you have, and even if you have customized bylaws that were done 5 years ago, 3 years ago, they probably don't apply specifically to short-term rentals that are advertised on Airbnb, VRBO, Craigslist, or Kijiji. So if the ownership wants to eliminate short-term rentals, and I would say the majority of bylaws that are being passed that we see right now are to eliminate short-term rentals, you're obviously going to need that 3/4 vote passed by the ownership. You're going to need that bylaw put in place. The bylaw should specifically address a minimum length of time. The minimum would be 30 days or 6 months. 6 months seems to be the most popular one passed right now. Investors that buy units are comfortable with 6 months. They understand it. Some of them are pushing back if you go to 12 months. So getting that 3/4 threshold at 12 months is a little harder, but 6 months seems to be the sweet spot right now. You need specific wording regarding licenses or other forms of non-tenancy rental. So some people doing short-term rentals have used the argument that they aren't actually forming a tenancy with the people that they're renting the unit out to, and technically they may be correct. So you need specific wording with bylaws to address that non-tenancy rental. And then it's a good time to clarify if the strata corporation's okay with home swaps, bed and breakfasts, and what the move-in fees are going to be for furnished units, unfurnished units, townhomes, tower. And a good time to clean that all up at the same time and as an open discussion. So short-term rentals, definitely a hot topic right now. And again, those are the key points you want to hit when addressing a bylaw.